May I please, Lords?
Yes.
That I was to recapitulate your Lordship's memory yesterday. I was showing to your Lordship the MDPA agreement and some of the clauses, that how it includes the existing laws, applicable laws, and the laws amended from time to time. That the leading judgment, the 9-judge bench in MADA, with regard to the state legislature's competency to make law for levy of royalty on certain the land, whether CORAM was correct or the India Cement was the correct view. Finally, it went to the 9-judge bench. The ratio, your Lordship knows that royalty is not tax. So CORAM was held to be a good law, not India Cement. So following that, one of our legislations which was struck down by this Honorable Court was revived. So in that MADA judgment, my lord, a few paragraphs, my lord, which have exhaustively dealt with the terminology of winning the minerals, mineral development, etc. You know, they have been very beautifully narrated in some of the paragraphs. If your Lordship would permit me, let me begin from that, because there are confusion that mineral matter. How to go to the book list? Yes. The book of the government site list here. Lord, I will not, it's a very lengthy judgment. I will not fill your Lordship's time much on this aspect, but except showing the most relevant paragraphs for the purpose of the present place.
Citation is 2024, volume 10. SCC
2024-10 ACC, Milan.
page is one.
Page one.
Page 1. It's the page 1.
My brother is more tech savvy, so he is going.
Going faster. That's it, must have been surfing ACC online.
He has already got. Yes,
But books have no substitute, Milan. So
No,
far, my
that may be my conservative view. That's my conservative view. I use this word conservative.
I belong to that school.
So I feel that reading a book gives me more than reading on the virtual mode. Yes.
Lord, may I most humbly take your Lordship to page 89, paragraph 92 of the report. A mining lease. Lord, what is the mining lease? Is defined under the MMDR to mean a lease granted for the purpose of undertaking mining operation and includes a sublease granted for such purpose. The expression mining operations, the word which your Lordship was pointing out yesterday, that has been substituted by production and dispatch. Mining, earlier it was in a broader term.
Without touching the meaning of the mining operation.
That still finds place in the definition pledge. Has been defined to mean any operations undertaken for the purpose of winning. This is important. Winning any mineral.
Why the word winning is used for the mineral?
That is there below.
No, I have seen in the statute also the word winning.
Winning is
Why not the exploration? Why not the extraction?
That has been
Why not?
defined in 79 Supreme
Why
Court.
the word winning is used?
Next sentence. The expression.
No, you
winning.
could not get what I'm saying.
I'm sorry. Yes.
There are certain expressions of the words which are used.
You're right.
in case of a mineral, I find that everywhere in the statute, the word winning is
Winning is
used.
there.
What was the purpose of using this word meaning?
Winning
Extractions, explorations, taking out the minerals, those words can be used in a very
Right.
common way.
Right.
The winning word means that somebody who does not know and then wins something.
No, your lordship is correct. The language of the statute should be very lucid and understandable.
No, there may be a purpose. There may be very laudable object behind it, winning. I just wanted to understand that why the word winning is used.
Justice Sarkaria in Tarkeshwar Thakur case, Millard, the next year, 1979 Supreme Court has elucidated what is this concept of winning.
Correct.
And
Yes.
1979 3 SCC Millard.
Yes. No, definitely I will go through it.
Yes,
Don't worry.
the expression winning, Millard, that has been also given in the 1979 3 SCC in explained to mean getting or extracting minerals from the mines. Millard, many words, your lordship is absolutely correct, have been interchangeably used. Production, dispatch, mining operation, winning, exploration, excavation, digging, so many words in different places of the statute, Millard. They have been very carefully worded at some places. But at times also, your lordship knows there may be a vague expression which conveys a meaning, but for a common man, a statute must be understood in the context it was enacted. There are many laws I come across very difficult. This IBC, till now I'm in a dilemma which is to be this bank insolvency code. It's so complicated. Maybe nowadays your lordship knows they're giving it to some consultants, PwC, etc. They are coming with so many complex provisions. Even at times, my lord, the lawyers and my lords.
That's a resolution professionals.
That's correct.
And the resolution plan, everything, the concept is different.
CPC, if your lordship, nobody, it's a 1908 enactment of the...
Prior there to 1892.
1892. So, Evidence Act, nothing can substitute this word. So lucid, understandable, plain, even IPC and CRPC, many provisions, there is no ambiguity. Even a law student can understand what is the meaning of this. Many colonial laws, British laws, I find very lucid. But of late, many new legislations are coming both in the parliament, I find, or that's up to your lordship to interpret and give a meaning to it. That's why the power of review, judicial review, has been conferred upon the constitutional courts. Where there is an ambiguity or a gray area, my lords come at the head of those legislature to clarify that no, they intended this. This may be the legislative intent, which is the wish of the people. Ultimately, that prevails. Similarly, observe that the expression mining operation is expansive so as to comprehend every activity by which the mineral is extracted or obtained from the earth, irrespective of whether such activity is carried out on the surface or in the bowels of the earth. Section 3FA defines production or any derivative of the word production to mean the winning or raising of mineral within the leased area for the purpose of processing or dispatch. As you hear, for the purpose of processing or dispatch. The expression dispatch has been defined to mean the removal of minerals. The word removal has also been used interchangeably in some places for dispatch. Removal of minerals or mineral products from the leased area and to include the consumption of minerals and mineral products within such area. That captive, I was telling some beneficiation plants which they have set up inside the leased area for pellet, ignots, like this. So dispatch area. It is worth noting that royalty is payable under section 9. I was showing this provision that it is on the quantum of dispatch, not on the production. That's the revenue of the state. On the removal or consumption of minerals by the lessee in the leased area. Thus, essentially, royalty is payable on the dispatch of minerals from the list area. That is a 9-judge bench judgment. So dispatch cannot be segregated from production. They have to be conjointly read so as to give a purposeful meaning to the statute, so that the purpose for which these mining leases are leased out to the lessee for the specified statutory period, they are under a statutory obligation to perform or to face the consequences of either termination or lapsing or whatever, or penalty. So in either case, the argument from the other side that we are not under a statutory obligation to dispatch what we will produce and take our turn whenever the price goes is not there. They are reading into the statute which is consciously missing. Consciously, they say it is missing. It is not missing. It is very much there. It's a part. It is ingrained. Both reading section 2, 3FA and the other provision of dispatch 3AA, 3AA and 3FA, Miller, and other provisions of the statute read with these auction rules, MDPA agreement, letter of intent, the tender call notice, all documents combined together, Millard, would form a composite Millard document or a comprehensive document to give a meaning to it. That ultimate object is to fetch revenue for the state, and that revenue would be utilized for public good. That is the bigger goal which the legislatures have kept in mind, and accordingly, the suitable amendments which was deficient maybe earlier, though it was in broader terms, mining operation from 1979, this Millard Takeshwar Shivo's case, though it was given a broader term, but still then Millard to make it more meaningful, more explanatory in nature, they have Millard consciously again inserted in March 21 amendment and subsequently in November 2021 amendment. These words, Millard, have been filled up wherever there was some lacuna. So this 4B, Millard, the argument that Rule 12A refers to 4B alone is not correct in as much as the rule-making power is vested with the delegate under Section 13 of the Act, which covers a very broader field. So that Rule 12A is a part of the MC Rules 2016, Millard, and this 4B is confined to the initial 2 years period. Beyond that, what would be there? Millard, that is a part of the MDPA agreement, and also the letter of intent, the lease agreement, the tender call notice, which, Millard, the tender is conducted in pursuance of the auction rules 2015. So, Millard, may I take your lordship now to some other paragraphs? Millard, your lordship may turn to now 92, then para 135. Sorry, 131. Page 103. Section 9 of the MMDR Act statute, got it? Maybe. Section 9 of the MMDR Act statutorily regulates the right of a lessor to receive consideration in the form of royalty from the lessee for removing or carrying away minerals from the leased area. Millard, here the word removing is used as a substitute for a dispatch. But in some of removing, dispatch, removing means, Millard, removal from the leasehold area. Either in the leasehold area, they may use it for the captive purpose, the consumption, royalty is payable on the quantity of minerals consumed, either in the leasehold area, that is an option, and beyond 50% they are, if it is a captive use, they are under an obligation to sell it outside. And royalty is payable on that. That is what the mandate of Section 9H. Leased area, away minerals from the, prior to the enactment of MMDR Act, such a condition was treated as part of a mining lease. The object of empowering the central government to specify rates of royalty for major minerals was to ensure a certain level of uniformity in mineral prices in view of the domestic and international market. Because this, Millard, rate is not static. This is flexible. dependent upon the market price and the marketability of the minerals or the demand in the both in the national and the international market. Let's suppose I am giving an example. During Corona COVID period, many countries could not import iron ores during the Corona. The price of iron ore became sky high, 8,000 per metric ton. So that is the reason why most of the lessees in the state of Orissa, they got a green corridor from Jodha to Paradip and exported maximum quantity of the minerals, which was not possible during 4 years. So therefore, those they can't be given the moratorium period to wait. You are under a statutory obligation. This is the requirement of your dispatch, 80% of the production. So therefore, if you fail, then consequences have to be followed. You compensate the state. This is the rate of royalty we are expected to generate. If you are failing to achieve the target of that minimum production and dispatch, then the consequence, ultimate resultant consequence will be entailing imposition of a penalty in consonance with the law. There is no informity. And here, the people in general, the state revenue would be strengthened. It is not that you achieve the target. You can be allowed to, suppose you fail, people are there in queue, they will come forward. It's not an absolute right vested in you that you can have the cake and eat it too. That can't be the option. That can't be the option. Similar domestic, then your lordship may kindly turn to 134 para. Under the MMDR Act, the central government fixes therefore, this delegated legislation, royalty is not static. It is, also in 5 years, it is revised. I will show the relevant provision, rates the rates of royalty, but it is still paid to the proprietor by virtue of a mining lease. In case the minerals based in the government, the mining lease is signed between the state government as lessor and the lessee in pursuance of Article 299 of the Constitution, because all government contracts are to be executed in the name of the governor. So through the mining lease, the government parts with its exclusive privilege over mineral rights. So this like liquor, your lordship, is exclusive privilege, state's exclusive privilege. So you are holding a license. A licensee, your lordship knows is certain statutory obligations and to perform his part of the duty. Failure entails consequences as the statute mandates. So a consideration paid under a contract to the government for acquiring exclusive privileges cannot be termed. This is very important. As an impost. It's not you can't say that no, we have a right, so therefore we'll use it as per our sweet will. Since royalty is a consideration paid by the lessee to the lessor under a mining lease, it cannot be termed as an impost. Repeated, the emphasis. Therefore, you can't use it as an impost. Right you have, rights are subject to statutory prescriptions and limitations. It is not uncontrolled, uncanalized, unguided. If you fail to discharge the statutory obligation, then it entails the statutory consequences. So your lordship may now turn to meaning of regulation of mines and mineral development, the next interrelationship between list 2 entry 23 and list entry 24, which I was showing to your lordship. The subject of regulating mines and mineral development is enumerated in list 2 entry 23. However, Parliament can under list 1 entry 54 bring the regulation of mines and mineral development under its control to the extent that such control is declared by Parliament by law to be expedient in the public interest, that is of paramount consideration. That is why Section 2 of the MMDR Act says it's a declaratory statute. All natural resources vests in the Union, mineral resources. Parliament must make a law. The law must contain a legislative declaration that it is in the public interest to bring the regulation of mines and mineral development. This is also equally important. The same term, mineral development, under its control. The law must lay down the extent to which Parliament desires to control the field relating to the regulation of mines and mineral development. List 1, entry 54, exclude the legislative power of the state legislature. Under list 2, entry 23, to the extent to which the parliamentary law covers the field. The interrelationship between entry 54 of union list, 23 of list 2 has been dealt with by this court in numerous decisions, which will be discussed in the Milord We are not. Your Lordship may now kindly come to para 148. As a concept, mineral development, the Milord 47, the Tisco case is also important. I will give the citation, 1996 9 SEC Milord. It was held that concept of mineral development can include captive mining and assessment of its requirement by different industries and equitable distribution of mining reserves. Tisco was decided in the context of unamended Section 83 of the MMDR Act, which allowed the central government to renew mining leases in the interest of mineral development. But we are not on that. So the next para, are the concepts. Mineral development is a term of wide import. It encompasses exploitation of minerals, reduction of wastage in the beneficiation process, regulation of mining activities for ecological and environmental factors, and equitable distribution of mineral resources and mining leases. Mineral development has been expressly recognized in Chapter 6 of the MMDR Act. Section 18(1) mandates the central government to take all such steps as may be necessary by making rules for the conservation and systematic development of minerals in India and for the protection of the environment by protection of environment
by preventing or controlling
or controlling any pollution which may be caused by prospecting or mining operations. Section 18(2), we are not much concerned, 149. The expression mineral development has also been understood under the MMDR Act in a comprehensive manner to include all activities and transactions relating to the working of mines, this is important, extracting of minerals, their storage and disposal, as well as the conservation of the environment. Having established the meaning and scope of this subject matter in List 1, Entry 54, and List 2, Entry 23, we now analyze the interrelationship between the two entries in great detail. But this context was why it came, that whether the state has the legislature, has the competency to impose royalty on the land. So therefore, not much. 167, one more paragraph. Yes. Milord, this is the public interest theory. This court at page 117, this court has to give credence to the public interest considerations underpinning the MMDR Act while interpreting its scope and ambit. Let you see the highlight. Ambit. The expression public interest occurring in both List 154 and Section 2 of the MMDR Act indicates that the provisions of the legislation do not merely cover the interest of private individuals, such as owners of private property or holders of mining leases, relating to the regulation of mines and mineral development. The public interest underpinning the MMDR Act synonymizes with the collective welfare of the people and is informed by the dictates of the public trust doctrine. At the same time, the underlying public interest has to be construed in view of the entire legislative scheme, purpose, and object of the enactment. Very beautifully, it covers everything. So, Milan, now It's not necessary now. So, my lord, the broader proposition which I most humbly draw to your lordship's kind attention is with regard to the Honorable Court's duty to safeguard public interests, because this royalty, collection of royalty, is not only meant to embolden the exchequer of the state, but for the promotion of welfare of the people. This beloved introduction of district mineral foundation and fund, that is basically meant for the peripheral development of the mineral bearing areas where the tribals mostly reside. If your lordship, Odisha, 7 districts of the state are scheduled areas, subject to Milord 5th schedule and the 6th schedule administration. So, Milord, in those areas, the miseries, the Milord abject poverty of the persons residing in this locality, mostly tribals, Milord, is untold. So, therefore, Milord, a state is under an obligation as for to translate the directive principles of state policy as enshrined in Article 39 B, Milord, to translate its or to direct its goal or the policies so as to subserve the public good, the public interest. So therefore, now if your lordship would come to some of the provisions of the tender document, the letter of intent, and also the MDPA agreement, which is a statutory document, what are the conditions spelled out which the lessee has unconditionally accepted. Because a party cannot take a U-turn after executing a statutory agreement, that no, this was not my obligation. I will only produce but not dispatch. It's at my sweet will. I will not wait for the period. So therefore, the state can force me or compel me to do my statutory duty of paying the royalty. So now your lordship may kindly have a glance at some of the documents, some of the documents which are very important. Beginning with let now one. What you think supermarket tender let this annexure no 5215 is the case which annexure 1 million tender document. We are following this 15 amendment and the expiry of the lease term
Each.
Please, your lordship, it begins at page 49, but I am showing you your lordship at page 121 payments. 53 actually. 53. Let's sum of the 52. Pillar 52, it from the clause 1, important information.
That has already been referred, I believe, because there is a marking I find.
Pillar, your lordship's slip must have been bookmarked.
That is already done, yes.
But page doesn't tally.
No, it tallies. Don't worry. 52, I need to say important information. 1.1 you are referring.
Right. Let's see. So let this tender document, I am reading 336 7th line. All informations provided in this tender
should be read together with an act and the rules thereunder.
Together with the act.
In the event of any conflict between a tender document and the act of the rules will prevail. That's true.
Yes.
That has to.
So, yes. So, then purpose of this tender 1.3 is to provide interested parties 1.3 with information that may be useful to them in making their bids pursuant to this tender document. These tender statements which reflect various assumptions and assessments arrived at by the state government in relation to the mineral block, so and so, were not then pays 54 million. The applicable law, 2.3 definition. Applicable law shall mean all applicable statutes, laws, bylaws, rules, regulations, orders, ordinances.
That's true, because it cannot go beyond that.
Yes, directive of any governmental authority, or official directive of any or court or other law, rule, etc., from the relevant government resolution, directive, other government, so broad restriction, any similar form of decision, any law in India at the relevant point in time. Similar, because 50 years lease is a long period. Law is not static, it's not rigid, it's flexible, elastic, timely. Suppose a society needs something, a change, or the resources require some bigger attention in some way. So therefore the parliament or the state, either case, they have the power to enact law to make it more people friendly. So therefore, the rigidity, there is no rigidity as applicable, because under this 50 years, this period, subject to, of course, not to lapsation and termination, because that is also an eventuality which may be taken recourse to by the government in the event of failure of a lessee to perform the statutory obligation. So auction rules, Millard, this is very important because they have come out as successful bidders pursuant to open bid, open auction conducted by in pursuance of these auction rules 2015 as amended by Mineral Auction Amendment Rules 2017 and from time to time. That's it, kind. And this particular expression from time to time also finds place in the MDP agreement which I showed to your lordship yesterday. So now, Millard, final price, we are not concerned. Specified end use. Then your lordship may kindly come to page 56, 3.2. In exercise of powers conferred by section 13
that's the bringing of the auction regime.
Yes.
No difficulty.
Mineral, in exercise of power conferred by section 13 of the Act, the central government has notified the auction rules and the minerals, evidence of mineral contents rules 2015. The bidders are encouraged to acquaint themselves with the Act and the rules made thereunder, nor that they have signed a document without understanding the contents. There is, on the contrary, there is a caution that you go through the statutory rules or the etc., etc. The post exercise which now they do in the court of law, they could have employed some good consultants like my friends to take the opinion and know what would be the consequence if we do not. So therefore, statute is very clear, unambiguous, specific, and it is result oriented. They want to give a meaning to it which is neither there in the statute nor it can be given any other interpretation but to conclude that no, a lessee is under a statutory obligation to pay royalty. That is the, there is a lighter vein. So we were, when I was a student, there was a bunch of slokas called Subhasitani from Manusmriti, Upanishad, etc. They were meant to ignite the young children that these are the principles, golden principles. Like there was, I still remember while I was coming to the court, that came to my mind, Danopa bhogahinena, dhanena dhanino jadi, prithvi khata nikhatena, dhanena dhanino bhya. Meaning, thereby, either if you have wealth, you cannot donate it, give it away, or you cannot utilize it. Danopa bhogahinena, you can't upabhog, you can't use it. So, prithvi khata nikhatena, dhanena dhanena. Likewise, under the earth, there is plenty of wealth. We do not know whether diamond will come out or gold will come out or chromite will, bauxite will come out or chrome will come out. So if that is not used for a purpose, it has no meaning. Everybody may claim that we are also rich. So therefore, any property, the necessary corollary, the resultant consequence is that it is to be used It is to be used for a purpose. Either you give it away, donate, or you use. Upabhog means to use. So therefore, what is the benefit if the minerals would be explored or excavated or wind or whatever terminology your lordship can give it? So what is the meaning if you do not use it? And that use is not associated with the states, the people interest, the public interest, collection of royalty. So therefore, my lord, your lordship may now come to certain binding provisions of the MDPA, which was contracted between the parties with open eyes. One forty. One payment. No, payment we exchange. Millard, one more, yes, I'm grateful. Millard, 121 page, payments. Payment of bid amount. The successful bidder shall make monthly payments on the basis of the final price offer. The monthly, that is called a monthly payment. The monthly payment shall be computed on the basis of the value of mineral dispatched. There is a spelling mistake, that would be DI, dispatched. In case the annual production is less than the minimum production requirement specified in clause 8, the successful bidder shall make payment on the basis of the final price offer on the shortfall within 20 days from the end of such year. For the purpose of compliance with the minimum production requirement, the expression year shall mean the period of 12 months commencing from the effective date of mining lease and his subsequent 12-month period thereafter. The upfront payment paid by the successful bidder shall be adjusted at the earliest in full against the amount payable in accordance with the percent of value of mineral dispatched quoted as the final price offer on commencement of production of minerals. But I may correct whether this is DE is correct or DI is correct. I think that is be dispatched. Two places. I think the book says DI. Or maybe this may be also correct. This spelling. Let it appear DE. Dispatch quoted at the final. Then the monthly payment is required to be made within 20 calendar days of expiry of month with respect to mineral dispatch from the lease area in such calendar month. In so many places, this dispatch is more important than also production. Equally, it is associated with that. Production alone is not enough. Dispatch is the emphasis is always on dispatch. You can dig it and keep it there. You are under a statutory obligation to remove it, to dispatch it from the leased area, and royalty is payable on that amount only, quantum only. So, any payment required to be by the source shall be on applicable taxes. In the event taxes are payable, the gross of the amount payable make payment of the other payments, minimum production requirement, the next page is the tender document. So the conduct of mining operations at the lease area shall be subject to annual milestones listed in Schedule D with respect to production, the minimum production requirement. The schedule is here, I'll take your lordship to that. The successful bidder would provide periodic information to the state government regarding compliance with the minimum production requirements in the manner stipulated in clause 5 information. Any non-compliance with the minimum production requirement, let us say caution, would result in appropriation of the performance security in the manner stipulated in clause 4, performance security and appropriation, and in case where non-compliance with the minimum production requirement exceeds for more than 5 instances during the term of the lease or occurs consecutively for 3 years, Such non-compliance shall give the state government a right to terminate the mining lease without prejudice to any other proceedings to be taken against the mining leaseholder. And all those is somebody with eyes open, sees the document, participates in the bid, and without falls upon the state government, why did you issue me a notice of demand? Royalties are not payable on vacuum, nor on production. Dispatch. So now, your lordship may kindly come to just limited mining rights. Next page, please. Because the past experience showed that they keep the leasehold area intact, started digging in the vicinity, the Saha Commission. They are areas because blood is not boundary is not possible. They just earmark it now because the satellite is watching it. They are otherwise earlier blood the adjacent land they would be digging. Their own area would be protected. One Uribur, that was a big scam, and he went on for 2-3 years. Lakhs of crores. So the person is absconding now. The state is not able to get him.
What is the level of accuracy so far as the satellite is concerned?
Satellite, AI.
The level of accuracy, I just thinking aloud that does it mean that it is so precise and so accurate that it does not invite any error of even a half a meter or even a 1 centimeter?
That now that is being streamlined. There is I think no, it is the hard theory. Let me be very frank.
There is these mapping. They gives the leverage in between
because lots of
to this. So sometimes it so happened. That's why you may have a mapping, but at least the physical, the inquiry, the physical visit is very important. Very important.
Squad, they are moving. Whatever corrective measures can be taken.
That is one of the effective tool to just have the glimpse of the incidents that there is a possibility of excavations or the extractions or a winning beyond the leased area. But actually the perfection or the accuracy can only be ensured on a physical visit at the spot. That will give you some idea, but ultimately it has to be.
We have many mining this deputy director, mining inspectors, mining.
So this is a restriction. This is a restriction which is imposed that you cannot hover around the outer peripheral of the lease area or something which is beyond the leased area. You can't go. You have to restrict within that.
Right.
So that is always, this can't be. Nobody can say that I can go beyond it.
Right. No, these clause have been inserted because of that.
To ensure that you live within the folds. You cannot travel beyond or transgress beyond the boundaries.
True. So now, you lordship me 124 mining plan and the applicable law. Mining plan applicable pursuant to clause B of subsection 2 of section 5 of the Act shall be complied with by the successful bidder at all times. The successful bidder shall also comply with the applicable law in relation to conduct of applicable law I have read. Your lordship may now. Phase 1. Yes. Page 140 Miller Schedule D. I was
page 140.
140.
Yes.
I'll make a synopsis in my written note. I will quote the paragraph with the relevant provisions of the tender document and the MDPA. 140, the Schedule D, which I was referring to just now reading. Here is the Schedule D. The successful minimum production requirement. The successful bidder shall meet the annual minimum production requirement as stated in the table below. Here is the computation. Year 1, refer to in 1 above, 24, then year 2, refer to 1 above, this Roman 1 below. Year 3 onwards, 80%. That is there in the statute also, my lord, which they have quoted. 24% of average sale price of relevant mineral published by IBM as applicable during the year of shortfall multiplied by shortfall in production, minimum production requirement minus actual annual production value of performance security appropriation. If they say that there is a guarantee, if you fall, then we will appropriate from this performance security. Yes. Then percentage of yearly production, this Millard asterisk, as per approved environmental clearance. That is Millard all correlated. But then Roman 2 Millard, Roman 2, Roman 1 preferred below means this preferred bidder success shall not have. This that was Millard with reference to the table. Applied for environmental clearance shall not have applied clearance for production of quantity of mineral which is less than the authorized annual quantity in the environmental clearance valid as on the date of expiry of the immediately preceding mining lease granted in respect of the said mineral block, sought approval for a mining plan for production of quantity of mineral which is less than the authorized annual quantity in the mining plan valid as on the date of expiry of the immediately preceding mining lease granted in respect of the said mineral block, provided that this requirement may be relaxed if the state government is satisfied that the quantity of mineral in application for the environmental clearance or the mining plan, as the case may be, is less than the authorized annual quantity as aforesaid, entirely for reasons beyond the control of the preferred bidder successful with. That's without force majeure event is also there. It's the act of God, etc. Certain eventualities. So subject to the terms and conditions of the mining plan and such other clearances as may be obtained by the lessee, the successful bidder shall be bound during the first 2 years of the mining lease.
That's the borrowing from the statute.
Right. Lease to produce at least 80% of the average actual production of the mine for the last 2 years of the immediately preceding mining lease granted in respect of the said mineral block. This is in case of a new lessee. This was the target of the old lessee. So this is
I can use or coin the word substituted new lessee.
Absolutely. True. So good. This will be incorporated, Miller, yes, 2 years or such period thereof during which the mine was operational. And this will be incorporated in the MDPA as the minimum production requirement. So this is the tender term and condition. And that has also been incorporated in the MDPA. So now you will achieve, Milord, I'm sorry, I'm showing this because it's such a voluminous brief. So you will achieve.
No, these are already referred at the time of an argument by the prisoners. So that's why I find there is already a marking.
Right.
So that's why I was.
Right. Milord, shown everything, Article 14 is equally worded for every lawyer and every law. But Milord, some people look it at differently.
Different, definitely.
Menaka Gandhi would not have come. So therefore, this article equality before law. So some people look at it in a different eye. Therefore, there is the institution of law.
Correct. Every time.
How you look at the provision. Wordings are same for Mr. Singhvi or me or Mr. Subramaniam or Attorney General. So, but and
no,
that
this is what my senior, when I joined the bar, used to tell me that whenever any matter comes to you, which involves a particular provision of the statute, you must read the section again and again. Right. You might have read that section 1,000 times, True. But still make efforts to read again. True. Every time you will find something new, because in the perspective of the dispute or the case before you, you will find something new would come out of it.
Absolutely, my lord. I am
So that is why I always read time and again, so that sometimes I find that something different can also be perceived therefrom. So don't worry, you can place it.
I am so grateful. My lord, may I intervene for a moment with your lordship? My lord, this young girl in 2020 during Corona, time, force in law in India, my lord, the last sentence or adjudication.
The same, this is the replica of what has been there.
Yes, Act, my lord, 1.1. Act means the MMDR Act as amended from time to time.
True.
You know, it is not in dispute.
Is a very common phrase.
Then your lordship may give, then mineral minimum production requirement pillar shall have the same meaning, 169 page.
Yes.
In the such expression in Schedule D.
Yes.
Schedule D, I have already spoken to your lordship.
The relevant point.
Yes.
Then mining plan means the mining plan drawn in accordance with clause B of subsection 2 of section 5 of by the successful bidder and the previous lessee in accordance with section 8B of the Act, read with clause D of subrule 3 of rule 10 of the auction rules, subrule 6 and 7 of rule 9A of the mineral other than so and so rules 2016. All are interrelated, my lord, these provisions. Then, my lord, monthly payment shall have the same meaning to such expression in clause 7.1.1. Then your lordship may kindly come to interpretation. I was reading yesterday, my lord, I had concluded here 1.2.1. Any reference? Then Roman 2 I was reading there, my lord, I stopped. There I had stopped. Such provision as from time to time amended, modified, reenacted, my lord, any reference to any statute or statutory provision shall include. Then Roman 1, all subordinate legislation made from time to time under that provision, whether or
There is
not
no
amended.
difficulty. There is
Yes.
no difficulty.
Yes.
That if there is any modification,
Your
any
company has
amendment,
this
any
agreement in the
incorporation, that
document.
would also include within that.
Yes. Then the same thing has been 1.2.5 and 1.2.6. Then compliance, 172. The successful bidder hereby represents and warrants to the state government, page 170, that it has been complied with all the terms and conditions of the Act and the rules framed thereunder, the tender document and other applicable law, as were required to be complied with by the successful bidder with respect to tender process for the lease area, and successful bidder is eligible in all respects to receive mining lease over the lease area. Also represents and warrants to the state government that it is in compliance with all eligibility conditions, relying on the representations and warranties of the successful bidder provided by the success, including the warranties provided under clause 11. The state government is pleased to enter into this agreement with the successful bidder for the grant of mining lease over the lease area to the subject to the terms and conditions specified in this agreement. So conditions for grant of, so this is not, then your lordship may kindly turn to 175. This is manner of appropriation of performance security, failure, monthly payment. This is the table, Miller. Appropriation event, amount of performance security to be appropriated. Then your lordship may kindly come to utilization of mineral, 170. The successful bidder shall utilize the mineral strictly in compliance with the applicable law, including the Act and the rules framed thereunder. The successful bidder acknowledges that the lease area has been reserved for the specified end use, and the successful bidder has qualified for the electronic auction on the basis of its representation that all minerals including 178, all including extracted under the mining lease shall be utilized solely for the specified end use and not be sold or transferred or otherwise disposed either directly or indirectly, provided that quantity of mineral equivalent to 25% of the total mineral excavated in the previous financial year for which end use was specified can be sold in the current financial year. The mining lease shall be for all major minerals found in the area subsequent to the auction. Percentage of the value of mineral dispatched as quoted by the successful bidder under Schedule 3 of Rule 8 of Auction Rules shall be applicable for the purpose of payment to the state government in respect of such mineral. Sure, here this undertaking.
These are all, everything is
Yes.
coming. Yes, there's
Mining
no
lease
doubt.
presents minor to establish so and so. It's not payment of bid amount, we are not concerned. Then minimum production requirement, page 180.
Same reproduction of the earlier obligations which is there.
180 Miller, clause 8.
Yes,
Clause-
yes, already there. 8.3, 8.1.
Right. All 3 minutes.
Yes.
Then your lordship may kindly come to the letter of intent. 171.
179.
1 Miller, 170. Payment of that is bid.
No, 179, 180, we have seen
Right,
that.
right.
There is no difficulty.
Then your lordship may kindly come to the letter of intent. I saw another Schedule D.
Yes, yes.
Schedule D, that's 196.
Yes.
This is from
Same thing,
195 requirements.
Same.
Same minute, verbatim. Repeated Milad at many places.
Only the distinction or a difference is
Yes.
that after this column, where the percentage was given,
Right.
here 12A has been quoted.
12A has been. Let's be scared. Let's put it. 203 is the lease agreement. That is annexure 6. The next document. Rights and obligations. The rights and obligations of the state government and the lessee shall be as specified in the act and the rules made thereunder, including without limitation the minerals other than so and so rules, concession rules, which is applicable to iron ore, and the mine development and production agreement dated 27/6/2020, which Millard the document which I showed between this, and all those 6 petitioners Millard have similar kind of documents. So at all times comply with the act and the rules thereunder and other applicable law. Millard this without prejudice, this is a general clause. The lessee, this is the lessee's obligation, 3.2. So then your lordship may kindly then the letter of intent. That is at page 219.
Page,
Page 219.
yes.
This from the steel.
That is the
and
18th
department.
March 2020.
Yes. The auction.
I think you will be referring paragraph 3.1.
3.1. Yes. Subject to the provisions of the Act and rules, the state government may impose such other condition mine development production agreement. So that forms as a Millard very intricate part. I mean, to say Bira?
50%.
Millard signing of the mining development and production agreement.
That's very important.
Yes.
They say he will not apply if he continues to extract the minerals in a similar manner or a similar quantity.
Right.
But if you want to make a production which is less
Right.
than the authorized, then he has to.
Right. So, the Roman 2 is important. This A, B Roman 2, subject to the terms and conditions of the mining plan, such other clearance, as may be obtained by the lessee, shall be bound during first 2 years of the mining lease to produce at least
That is a
80
statutory.
Yes. mining
provisions.
lease, mineral block,
Yes.
MDPA minimum.
That has been
provided
put in as a part
requirement,
of the letter
Yes.
of intent.
grant of mining lease, validity,
Yes.
etc. Now, your lordship may kindly come to vesting order. This is important. They have much arguing on this. It is limited only for 2 years, not beyond that. For the seamless millard production, as Ronde AG Attorney General was arguing, your lordship was pointing out that yesterday. I'm so grateful. So this millard, these are the, because he was not the lessee in respect of this particular iron block. He became a fresh lessee. But the last 225 pages. Huh? Old lessee. Also, old lessee new. I'm sorry. Old new both. But still then, this protection millard applies both to old and new. Even if you do not have, if he has a statutory clearance, that you can use without prejudice to the generality of the provisions of 8D2 of the MMTR Act. The details of the valid rights, approvals, rights, clearances, licenses, the like held by the previous lessee and vested.
That is
in
also
favor
a
of-
statutory provision actually that vests. You
that,
did not have.
that is there. And no, last is millard. This vesting order is valid for a period of 2 years.
True. That's
So therefore, seamless production. So therefore, this 2 year, then the 3rd year, that is millard specified in the MDPA agreement and also in the statute. They say only for 2 years we are under obligation. Rest millard, the state will.
Yes.
How can it? Then it is for 50 years, the same. So there, millard, now millard, your lordship may kindly come to the demand of 21. Millard, other things may not be necessary. Millard, the argument of, I'm coming one by one. Your lordship may, Minister 19, page 275. 275. Millard, here is a show cause of 16th August 2021. This is for the first 2 year period. And later was issued in August 2021, much after the amendment, post of March 2021. Here was, may I read this? With reference to the subject cited above, I am to say that as per Schedule D of signed MDPA and Rule 12A1 of the MC Rules 2016, you are required to dispatch 22,76,400 metric ton of iron ore during the first year, that is from 29/6/2020 to 28/6/2021, in respect of your RADA 2 iron ore block. But after verification, monthly returns, it has been observed that you have dispatched only 1,53,126.210 metric ton during the said year of leads, with shortfall of 21,23,000 so and so quantity. You are hereby noticed to show cause as to why you shall not be directed to pay the following amounts towards shortfall in dispatch, vis-a-vis the minimum dispatch required under Sub-Rule 1 of Rule 12A of the mineral other than atomic and hydrocarbon energy concession rules 2016, which you have agreed to pay through MDPA by maintaining minimum dispatch requirement. But the total demand was 1483.74 crores, 1483 crores and 74 lakhs. Milord, your lordship may kindly turn to the next page. You are further notice that your reply, if any.
Oh, that is a common thing.
Natural justice, Milord.
Oh,
So
that
yes.
is always there.
No,
Show cause.
you may appear in person He was heard also personally.
Yes. Yes.
Person through your authorized representative on 31/8/21 at 4 p.m. in the office of the undersigned. You may further note there would be no further hearing. It is by operation of law this demand could have been raised. But my lord, for the purpose of compliance with the principles of natural justice, the contention that natural justice was not given is not correct, absolutely unfounded. Then your lordship may kindly look at their reply. This demand notice, then they came to High Court in between or some order that the it is something else. It has nothing to do with this. This Honorable High Court's order is with regard to some company's intervention, anything not connected. So then your annexure 21. They took advantage, I think, the last year. At this request, as Mr. So-and-so, Learned AG, seeks a short adjournment. How many times it has been? 21. There is a no coercive order. I think the case has not been listed. We file the counter now. No counter. We file the counter affidavit recently. I should not say more. Let me not be vocal. So, but your lordship may see the response. 8/9/21.
Yes.
No coercive action was ordered at his request list on 29. Till then, no coercive action. And by automatically, till then means 29 June 21. Technically, there is no interim order. Unless it has been extended. I don't think I was telling them to find out if it has been listed in the meantime. But now, after 4 years. Demand on shortfall in the minimum dispatch required under sub-rule 1 of rule 2. This is the revised demand pillar we gave. Office demand on, that is on 8/9/21. Whereas Navarham Power and Steel, they give the Steel Limited has quoted the highest bid of so-and-so, 90.9% in the electronic auction, whereas preferred bidder has made payment of so-and-so, whereas payment of second installment, so-and-so, then Millard, your lordship may skip, and whereas you are given an offer, this is the order which was passed. Millard, may I read this? Whereas the lessee has agreed by clause 8 in schedule D, entire everything has been discussed, then your lordship may kindly come.
No, this is not an order. This is also a notice.
Yes.
This
This
is also a notice because if you come to case 281.
No, Millard, no, this is the final order. This is the impugner.
Yes, 281 if you come. 281 you are referring.
Right.
Heading is revised demand notice.
Right. It's a demand. No, they have this language. This demand. This is a revised
demand notice.
No, subject is demand on shortfall.
Oh, but above it.
Earlier.
Above it.
They say demand notice means demand order.
Anyhow.
Yes. No, it's the final order.
Yes.
After.
Nowadays, demand notice is first. That is proposed demand notice.
Right.
Suppose one demand notice.
It should have been demand order.
No, the order follows that.
Order
after reply.
Right.
Consideration of final explanation.
Right.
Final order.
They gave the reply.
Anyhow,
the reply has been considered. Reply has been considered. Opportunity of hearing personal, they were present for personal hearing.
So
after that, this order has been passed on 8/9/21. My lord, 283 two paragraphs. My lord, Justice Raman is correct. So and whereas you have been intimated by this letter number 13. My lord, this at times also your wrong description in a document doesn't invalidate that order. It's a settled law. Even if a wrong provision of statute has been invoked to pass Justice Pradipta Rai judgment. I was arguing in 2000, a wrong provision was quoted by the registrar. Yes. And whereas, as per Rule 12(1)A, the annual target of minimum dispatch of iron ore has been agreed.
So what happened to the interim order that was no coercive?
No coercive. We have not been able to
it does not prevent in adjudicating.
Yes.
Yes. So this is how it has been quoted.
Yes.
And because they did not reply on a merit, it has really come up.
Right.
They were taking shelter under the interim
But
order.
revised also, it was revised to 1396 crore from 1481. Initial demand, maybe certain things, Millard, after hearing them, it was reduced, Millard. It was from, let's say, got it, Millard.
Yes.
As per the demand, it was annexure 19. So, certain 1483 crore. Millard, after hearing them, it was reduced to 1396 crore. Around 90 some odd crore was reduced. There is this the final order. There may be, Millard, at times arithmetic calculation or etc. They might have said this is not due. So, Millard, this para 283 and whereas para 283, Millard, last two lines. The value of shortfall along with differential royalty, DMF, NMET and value of performance to be appropriated. You have also been notified this office letter number for a show cause, because this royalty is also GST is payable on this royalty. DMF District Mineral Fund is payable on this royalty. Three components. So they evade. For last 4 years, Millard, if it is with interest, it would be calculated now. It would be almost double, Millard. 2,600 crores. And that is the benefit of the interim order which they have got by now. Not less than 1,000 crore. Not less than. I was talking to the mining officials. This may be the quantum. So this way, Millard, let's see, may now turn to now, therefore, and whereas you are, 283 I was reading. Now, whereas you are given an opportunity of hearing and the case was heard on 31/8/2021 in the presence of his representative. Your reply submitted on 31/8 to the so-called notice submissions during hearing. That's it, may kindly mark. Submissions during hearing. Can take a plea that we are not heard. You are heard and the content of the hearing might not have been quoted in an administrative order. But the fact remains by operation of law, you are under an obligation to pay the royalty at the rate quantified or specified in the statute. No need for personal hearing, in my humble opinion. Millard, there is no need. Suppose in a tax demand, why should someone be heard if he has evaded tax to the revenue, to the exchequer? So notice coach, still then, Millard, still then, natural justice has been fully complied with a written show cause, personal hearing, officer or the petitioner has been heard by the officer, and Millard, a reasoned order has been passed that this is the requirement. You have derelicted, defaulted in your statutory obligation and duty. This is the state's due, you pay it. And 21, Millard, in the garb of that again, 21 was, Millard, not then 25. The same demand has been reiterated. So they came in 25 again. So by challenging this 21 still demand. This hide and seek game, ultimately, Millard, maybe temporarily you may get relief, but not at the what is this? Deputy Director. No coercive measure again, Millard. Millard, if I kindly look at it, 25 again, the same demand. Same demand. They come in various, Millard, forms. वो जो क्या बोलते हैं चर
But it's a kind of reminder.
No, they same. Yes, 25 Millard. The next
That is-
annexure.
Is it 15/1/2025?
कितना सेटा? Yes, annexure 22 reminder. The same 21, it's a reminder.
Page 280 now.
A fresh challenge.
Oh, 22.
Let's see.
Reminder one.
1396. And that too without interest because
Continuous.
Millard, they respected the lordship's order, no coercive, so therefore they have repeated the same thing. How, Millard, this is a camouflage.
Yes.
Millard playing tricks with the court. 21 something, the same demand. It's only a reminder. But I don't think, Millard, I should be killing your lordship's time any further. This is the case in all cases. Facts are identical. Laws have been, Millard, placed before your lordship. I will prepare a written note, very comprehensive, precise, concise, and short to the point objective. Lord, if your lordship would permit me, I may take a week's time. By 29th, next I will prepare it. So as short as I can, and the relevant annexures, provisions of law, with the decision cited. Other decisions are there. Let me not waste your lordship's precious time by citing the reports. I'll give you whatever relevant. My lord, I'm deeply obliged and grateful for your lordship's kind.
No, thank you, thank you. You just submit.
And I apologize. Lord, in all these cases, only 4 cases state revenue, WPC Tata Steel ka demand 2410 crore. And then Milord Navraham is 1396 crore, this one. Then your Milord Ghanshyam Misra is 55 crore. Next page, Milord Tata Steel is again 902 crore, 192 crore. And Ghanshyam Misra is again 58 crore. Total Milord comes not less than 4,000 crore.
Yes.
Annual excise revenue of the state 4%.
Yes.
I'm
Learned Advocate General concludes his.
State Pollution Board under annex of High Pilot. That is the notice was made on that is in Oriya language. I'm reading that there's on 28.
Can't you give me a translated copy of it?
Malad, I will supply that.
Why don't you deprive me from reading the content thereof?
I better. That is not this time.
What is this? I do not know. Give a translated copy.
SPC.
2 weeks.
Item number 5.
Directed to find this translated copy of the annexation in 2 weeks. Yes, sir. What is this?
Lordship, I filed this honorable court to bring into notice the illegal mining scam in the state of Orissa and the district of Yora. Knowing about this illegal mining scam, the central government appointed a commission headed by Justice Sindhi for investigation into this illegal mining scam.
Union of India.
And also a case was filed in the Supreme Court. Common cause. Whereas Supreme Court ordered Central Empowered Committee to also inquire into this illegal mining scheme. Both of them, Justice M.D. Shah Commission as well as the CC, came into a conclusion that massive illegal mining scam has returned.
That is Justice Lokur's judgment.
Yes, Justice Lokur judgment. Yes.
Yes.
And after this Supreme Court Justice Lokur judgment said that 100% fine for the illegal mine owes must be raised from the
What the rule says, how much is the rule prescribed any amount of the penalty on the percentage basis or
this is
a fixed amount?
114 of booking judgment.
No, I understand. No, there is a rules and there is an act.
Okay.
The illegal mining
Yes.
that is done, there is a question of any penalty.
Yes. If the judgment
Is there any provision in the act relating to a penalty, or obviously certain actions to be taken against those
yes.
offenders,
In the order
both in
of-
criminal, it's a criminal liability as well as the civil liability, both.
Yes.
Is the rule provide for that? Or a act provide for that?
Yes, it's in section 25 of MCR Act 1960.
Section?
24 A1 of MCR 1960.
Because you are coming for a direction to impose the 100% of the fine.
Yes.
That is what I really
Yes,
wanted.
according to Supreme Court's Luku.
Where the Justice Lokur has said that 100%
Yes.
fine has to be imposed.
Yes,
Can you show me the paragraph?
that's paragraph.
You have annexed a copy of Justice Lokur's judgment or not?
Yes, 116. This is annexure 16, page 512. And in this annexure 16, please see para
Supreme Court
153.
judgment is the informed order. Yes, sorry. Yes, what?
In annexure 16, please.
No, I got it. Running page, can you give me?
590.
590.
Para 153.
Just one. Yes. Yes, who is for the state? Why you are not implementing the judgment of the Supreme Court? It's a law declared by the Supreme Court.
Yeah.
Why?
Have you seen?
Is there anything which they have done imposing lesser penalty?
Lesser penalty as well as total.
Where? Have you demonstrated?
Yes,
Any document?
I have this document, I have prepared it, the gist, where we can easily
You have made only one mine owner as a party.
because
Opposite party.
he can't be the minor.
Party number 6, he has illegally operated.
He is the only one,
Yes,
none else.
none else.
Yes.
Regarding that, I have to take instruction what steps they have taken. after-
No, he says that when the Supreme Court has
Yes.
said that all these illegal miners
Yes.
or the mining activities, the state should not show any kind of a leniency. The state must immediately activate the provisions of law and will impose 100% penalty over the same. Now he has come forward and says that you are not imposing 100% penalty. Are you not going or acting against the judgment of the
So
Supreme
once
Court?
there is a judgment, the Honorable Apex Court, we are.
You are bound by
Yes.
it.
And state of Odisha was also,
A party there.
yes.
So
So I'll have to take instruction what steps they have taken without that.
no, he's showing that you are charging less than the 100%.
And the quantum also has been decreased. Please see the right column, that is manganese. No fine for manganese. Basically, this is iron and manganese mines. And no fine for manganese previously assessed. 5,80,306.4 tons have not been taken into account. 31,217 metric ton have not been taken
So
into account.
it is really burdening or depriving the state to its exchequer.
And next page is, I have calculated according the fine of manganese in the next page. It's coming to, as per the chart, mentioned in this letter number 820, that you can find in Annexure 14, these rates. This comes to 1,126
6 crores.
60 lakhs 16,649.52 only in Bangladesh. They have,
And iron ore is 1930.
and iron ore is
1930 crores.
no iron ore is 805 total manganese and iron ore. If you add, it comes to 1,930 crores.
Correct.
Each side.
Both.
Lakhs. Yes, both.
So 1009, your Advocate General in the earlier matter was saying that we are being deprived of 4,000 crores.
And
So that is in relation to a dispatch or a production. Now, if it is an illegal, then why the government is depriving or the state is depriving itself? It's nearly 2,000 crores that would come to your exchequer.
this is the calculation from 2005. But this person doesn't have any instrument of release these.
Whatever. Then
That I'll have to produce, what he's alleging. He's alleging prima facie it appears to be there is a violation of,
absolutely.
but I'll have to take instruction from the authorities what has been done. Otherwise.
The instant writ petition Call one matter.
Item number 6.
Tag interim order. Delete from Supreme Court order is valid. Encroachment.
Yes, Madam. I have offered instruction in this document. The allegation made by the petitioner is partly correct. There is no force in the government, public road in this. Now the prosecutor has directed for demarcation to acceptance of only
And then initiate a proceeding. Should I record that?
Yes.
And then dispose of, no difficulty. The instant writ petition in the nature of the public interest litigation is filed by the petitioner, being a public spirited person.
Let's see.
Attachment again is the problem.
Yes, my lordsman, I've given the instructions, my lordsman. See, we have initiated encroachment case with my lord, and Form A and Form B notices were given. And against that encroachment notice, my lord, he has filed a.
So there is already an appeal. Any order
Yes,
is passed.
Order is not passed, my lord. In December only he has filed the appeal, and on 5th of this month we have transmitted the records to the sub collector.
Okay.
My lord, talk to my learned friend. What happened, my lord? The present opposite party number 6 has encroached the Brahmya Jungle Road upon which appeal has been preferred. But we are not agreed with that plot, my lord. That plot is adjoining to road. He has encroached the road. On the
No, understand,
upon
sir.
that road, no enforcement proceeding
What-
or anything else.
Yeah, what my learned senior is saying, the plot over which he has encroached, in front of that there is a road. So he's also encroaching on the road. So once he is removed from that plot, that road encroachment will automatically go. So he has to be removed from the plot on which he is now encroaching.
Correct.
And
If he is encroaching a particular government land, whether partially it is on the road also, if he is removed from there, then he will remove from the entire thing.
Well, the case is that
The
that
case
person
is
has
not.
already
Sir.
leaked out a
Sir,
under annexure
your
code.
concern is shown. A proceeding has been initiated. If he is removed, he will be removed with the lock, stock and barrel. Don't worry. So what is that? And there he has already gone for an appeal. That is his right, statutory right.
That is on plot number.
Whatever is there,
Well,
Now, this plot is Ghorbadi. Annexure 4 is Ghorbadi.
he has been leased out, my lord. But he is not going to that area. He is encroaching another plot.
whatever.
Well,
That is okay.
The present writ petition in the nature of the public interest litigation
Irregularity committed for awarding the tender work in the opposite party number 567.
Why? What he has done?
If your lordship sees that of for two, which are.
I'm asking you what he has done.
The cost of the from the cost of the tender, 14.99 CSR amount to be deducted, my lord. 14.99 amount, 14% 99 percentage of 14.9 to be deducted from as a CSR, my lord. That is in page number 21, my lord.
So,
Yes.
so
But despite that, even though it is fixed that 14.99 to be deducted, but very less amount was deducted, my lord. Very less. Your lordship see that page number
who are you?
21. I am an RTI. And my lord, it's a public money is involved. So on the basis.
Why you are not deducting the 14.99%?
Tender has been issued by Chodwar municipality. The notices have.
Notice. 3 weeks.
Item 9.
In the year 2018, the Tahsildar invited.
Just 1 minute. Yes.
Yes, it is. The Tahsildar Bizarpur in the year 2018 made an advertisement for 5 years lease in respect of curie of sand from the soil at Farasota River Sandbed.
So 5 years expire in 2023.
My lord, in the year 2023, that lease was cancelled on the ground. If the lease will be continued, that it will hamper to the HL bridge, my lord. If your lordships kindly see.
No, then what?
My lord, now.
So it has come to an end.
My lord, now
Lordship must see page
now
7, ground number A, that is the whole case, my lord. He wants that lease deed is to be cancelled, you know.
My lord, I'm some. If your lordships kindly see the.
Yes.
Annexure 3, my lord. Annexure 3.
No, whatever. So the query agreement has been entered into in 2025.
25 minutes.
So
My humble.
it has been done after an auction has been done.
My
So
humble.
what you were doing? Why you were sleeping in a slumber when the auction notice was published?
No, my lord, and suppose I am unable to express my lord. If your lordships kindly see the.
Now you say your locus standi. If you wanted a cancellation, is it not a civil dispute? Can a writ court go into PIL is maintainable?
If your lordship only for moment annexure 4, my.
I am asking whether the PIL of this nature is maintainable.
My lord, now I'm the villagers, my lord.
Maybe
Now.
that does not mean that you can file a PIL. There are rules.
No rules, no. If your lordship stand for a moment, annexure 4, my annexure 4.
What?
19, my
What? You wanted to settle your personal score into it.
No, my lord.
Definitely.
If your lordship for a moment.
Definitely.
For a moment.
Yes.
Annexure 4.
Huh? We will, if we find it is absolutely, we'll impose a cost also.
My lord, before going to the annexure
Yes.
4.
For yes.
Annexure 2, my lord. Inquiry report, my lord.
First, you make your mind firm. Annexure 2 or annexure 4?
Annexure 2.
Annexure 2. Page.
My lord, page 15, my lord.
Yes.
My lord, that lease was cancelled on this ground.
Just.
My lord.
Maybe
My lord.
that was in 2023. Then
My lord, thereafter, people also kindly see Annexure 4.
huh?
Annexure 4, page 19, 1
Huh?
my lord. With lordship's permission, my lord, I
Yes.
place the relevant person, my lord.
No, maybe. Anyhow, dismissed.
My lord,
Maybe it says not feasible. Then
my lord, thereafter, now the
That is
again the lease is
2023.
that's I've seen that 14.9.
2025, again, the same person got that release.
Let us see. Yes. Then
thereafter, avoiding this order, my lord, now the lease is between the same person with the mining department.
sir, have they not floated a tender? Have they not invited? What you were doing? If you are so, I think you are the activist. Then why you sat over the matter,
That is in the year 2025.
sir? They must have floated the tender for awarding this particular quarry lease. Somebody has participated. What you were doing when the tender was floated?
My lord, that is my point. There is no tender.
What are you talking? Where you have said?
This is
Where you have
2018.
stated?
This is 2018.
Where you have
Yeah,
stated that no tender was floated? Show us.
No, 18 the tender is. That the tender was made in the year 2018.
18.
My lord, that was cancelled.
Oh, that was cancelled.
That was cancelled.
Show me that they have not floated a tender.
My lord,
You are talking about. Show me where you have stated in your petition. Show me.
my lord,
Show me.
4.6.
4.6. Yes.
When the matter stood thus, that lease was cancelled, my lord.
I am asking you, you have said orally that no tender was floated before this lease was executed. Where you have stated this fact.
That
Sir, this is what is the recurring feature I have been noticing. You are a very responsible member of the bar. You will not say anything which is out of record or beyond the record. A lawyer is always supposed to argue what is there in the pleading, and on the basis of the pleading he argues. You are making out a case of your own, which your client has not made out.
You have any idea? The 2018 tender that came out to be not feasible subsequently.
I have only obtained the instruction.
I have simply, because I find that there was a tender floated in 2018, and on the basis thereof it has been done. And he says that the tender has been cancelled, but he has not said anywhere specifically that it was cancelled. Rather, the successful tenderer who is now have been awarded, he made a representation, and the court, disposing of the writ petition, directed the disposal of the representation. The representation is dismissed on the ground that it is not feasible. Has he challenged that order?
I will take instruction.
He has not challenged that order. Is there any other order? Give a notice.
So in that sense, there may be loss of revenue by virtue of that
Let us- the representation by the lessee was dismissed.
Oh.
Three weeks.
Mr. Naik,
I'm sorry.
sorry, what sorry, Mr. Naik? You have been practicing since long. Come forward with a clear picture.
What?
Clear
Next
picture.
item.
Item number 10.
Lecture one. Lecture one is pending, that is the representation by the sellers and some other.
So what kind of a public interest litigations are coming? They are making a single lane. You wanted a 2-lane should be constructed. Do you know to have the 2-lane, what are the requirements and how among us task it is to widen a road?
Initially, they decided for the same.
I am asking, sir, it requires an acquisition of lot of lands.
No, it is existing. No, acquisition.
Is it existing? The 2-lane is existing or a single lane is existing?
No, initially, one of the single lane was there.
I am again asking, they may have at one point of time decided to widen it up.
Yes.
For the widening, there may be some land of a private individual which would merge into this.
So that is what has happened, my lord. That is the clear picture I'll give, my lord. The road from Kotak to Chandal is there. It goes through the Ketrapada town. And that Duria Junction, the national highway is, has crossing that road. So under that road, there under bridge is they are constructing. Initially, it was 22 feet. Despite that, my lord, it was accident prone area because that is a junction. Now, my lord, they are squeezing to 17 feet only. Where are the demand?
Are you an expert?
No, my lord, that is the.
I am asking, are you an expert in those branch of the system, architect, or you are expert in the lane and all everything? That what should be the width, what is there? Are you an expert in this regard? Why the court? The court is not supposed to give his own views. Then the administration would run into the court.
No, that is why, my lord.
If the experts have gone and they have given a report that this is what is possible and the feasible, I do not know that.
May I break one thing, my lord? If you also issue notice to the OP number.
Definitely, why should I? We will encourage the litigations to continue pouring in the docket of the court.
Because, my lord, now, my lord, what has happened?
Where is your independent observations? Have you engaged any expert who has come and say that this cannot be done?
No, that.
Then you suddenly one day you've thought that it has to be done in this way. And the court will just simply on the ipsit dixit of your opinion, the court will issue a notice.
My lord, the local people are protesting for the same.
Maybe are they the expert on that? If they are doing an underpass and they say that's a 17-meter,
yes, sir.
What more?
But because, my lord,
Visibility, you say 22 meters. It may affect many things. We do not have any idea, no material.
My lord, a 4-lane road. That is from Kotak to Chandali, and it is crossing to that particular junction. But at that particular junction, my lord, a 4-lane road, in that area, it will be too close, my lord. It is too narrow. That is the.
Sir, this is what we call it a bottleneck sometimes.
Yes, right.
It all depends upon the feasibility. It all depends upon the viability. You cannot avoid it. They can widen the road sometimes for some stretch. It will be say around half of it, but that does not mean feasibility, viability. Many factors have to be seen. The court will impose his opinion, or a layman who does not have an expertise. Why don't you appoint an expert and then come and give a report?
They have they have approached the authorities. Let them take a decision because it's for the benefit of the
Then
people.
you have chosen a very wrong forum or a court. I have a strongest of reservation against the consideration of representation. First thing is show us your right. why I will create a illusory cause of action for this next round of litigation? Why?
Because it is for the.
This is what is
Because the local people, so
Sorry.
people are black manner that.
No, sir. No, sir. This is not. You have to come with the materials when you are coming in a public interest litigations. You have to come with all the materials to show that yes, this is justified and the government is not doing it. There's a violation of our directive principles, the violation of the fundamental rights, or the violation of any statutory provisions. Show us in the public interest litigation. You have not done anything.
I will permit the with the liberty to solve with.
What liberty? PIL does not. You have no materials before us and the PIL is coming. Withdraw.
Item 11.
Millard, last occasion the petitioner didn't appear, but Millard, his grievance is redressed, Millard.
Discuss with.
Item number 12.
Last occasion also don't appear.
What is there? Anybody appears?
No. No.
No, there was Ashish Kumar Mishra.
Last.
24. What is the school? This degree college is a government degree college or a government aided degree college or a private degree college? I think it's a private one. No, maybe the government.
It is Millard aided college, not common.
It's the area.
The representation on the annex of 4.
Yes, listen to these. Which is discuss.
Item 13. Item number 13. Item number 13.
PIL mail, either two reapplication.
Minutes?
Two reapplication as well as content application has been disposed of mail. In spite of that, they have not yet complied. And next 3 alerts were glance. Has repeated WPC number 18,557/21. This Honorable Court directed to take a decision my lord in spite of that. Again,
My lords, what happened in this matter is the person, Biswajit Barik, he has his private land adjacent to the cremation ground. So he uses the cremation ground as a way of passage to pass, to go to his private area. So there's no obstruction, there's no structure on the cremation ground.
Other means or access.
there is no other alternative way to go to the cremation ground.
What?
So the,
Only one cremation ground of the village, my lord. They have unauthorized occupied and constructed a house over there.
No, they say they have not constructed the house over the physician's land. He has constructed a house over his own land.
yes.
Only the cremation ground, which is an open one, he is using for his ingress and egress. Nothing more than that.
Oh, ma'am.
That is your case.
Yes, ma'am.
And except for the lordship lands contempt application dated 20.
So what is this? This is, I know, representation consideration, not considered contempt. Does not mean that your right has been.
No, thereafter they contempt, they have admitted we have complied, but subsequently they have not yet complied, my lord, page 24 to
Then you
27.
go before the contempt court. For the contempt.
Subsequently,
Or go and say that this statement is wrong. He says that
after contempt, my lord, the petitioner filed another writ application, annexed 5 your lordship having lands, page 28 to 30. Order.
you have said that he has been evicted.
My lords, no, there's no one is residing on the cremation ground, no one's using this just for the way of passage. The person, the alleged encroacher, he has his own private
Yes.
land, he's staying in that private land.
Let the,
Page 30 if you come.
let the inquiry made by lord.
Page 30.
Yes, ma'am.
Yes. What is this?
My lords, as per the instruction that I've received,
What happened to the saloon?
When
that I
you have
What happened to
received
the
this,
salon?
when you have received this instruction, have you not verified page 30?
no, my lords, I have,
And then-
I'd asked them about this, I'm just
Then what
awaiting
about
the
this?
instruction.
What about this pilot seeks an information from you?
And this was just provided to me today morning, and that said that there's no illegal construction over that area.
Will not be, what about this order?
No illegal construction, then come to page 30. What he has said.
I was party to that.
Is it not an illegal construction? Look at it. What you say.
Order.
I confirm that.
Mr. Ranjit,
Yes.
uh, you have alleged against two persons.
Yes.
Opposite party number 5 and 6. Against them, there is no enforcement. Five uses that land. Opposite party number 5 uses that land to access.
And let them take instruction whether they.
Is simply using his embarking on that barren land for ingress and egress. It does not mean he has made any construction or obstructed. Your instruction in this matter from your client is absolutely wrong.
High has constructed a saloon over
We
there.
are, which place? Which place, this property is?
That's plot number 509.
Oh, I am asking which place means, which area, which.
Oh.
How far it is from Gata?
Let's make.
Within 80 kilometers.
Megha.
Within 80 kilometers. Katta Bata दिवस sir. Maybe Katta Bata. କଟକରୁ କେତେ ବାଟ ସାର୍ ଏଇ ଜାଗାଟା?
Kotapur 80 kilometers, sir.
80 କିଲୋମିଟର ସେପଟ ତ? କେନ୍ଦ୍ରାପଡ଼ାରୁ କେତେ ବାଟ?
25-30.
କେନ୍ଦ୍ରାପଡ଼ା ଭିତରକୁ ନା ପୂର୍ବରୁ ପଡୁଛି?
Kendra shared Rajkoni.
ରାଜସ୍ଥାନ କାଟ। ଏଇଠି ଭିତରେ ଆଉ।
We are appointing a special officer here, the member of the bar, he will go there, he will bear the cost. We will see, don't, you have to bear the cost of his going and there, when you are making an agreement.
The gate may
That is still the construction is going on or is still there. We are simply directing one of the officer of the court to go there and submit a report to us.
It's not that may fix so that I'll take instruction.
No, we are appointing a special officer. You are very vociferous in your submissions that they are not giving a clear picture. So we are appointing, this is which.
Let me-
Kendrapara.
Let it come day after.
Any member of the bar who has a residence at Kendrapara? Having a 5 years of practice? Or over?
ରାଉତପର୍ତ୍ତନୀ ଭିଲେଜ।
ସମୁଦ୍ର ପାଖାପାଖି ସମୁଦ୍ର ପାଖରେ
ଦେଶ ପାଣି ଦେଇ
ଭଲ Panela belongs to Noyagarh district.
वैसे ये मुझे जानते हैं
Is in Kendrapara.
On the same route. On the same line.
He's from the
Belongs-
same area.
On the same route. Salip.
Salepur Kendrapara both the roads.
That's far off.
This is near the sea. Where Ganga is standing.
35 kilometers।
Any.
Chandpani.
We are appointing.
Recent.
5 ବର୍ଷରୁ କମ୍ କିଏ ଅଛନ୍ତି?
No. Yes, very late.
But she's competent.
That may fix so that I'll take instruction regarding.
Appointing, yeah, it is a very pertinent point. So let us be. Yes.
ତ ଗାଁରୁ କିଏ ଇଣ୍ଟରେଷ୍ଟେଡ ନୁହନ୍ତି?
ଯାହାକୁ ପଠେଇଲେ ଆପଣ ଯିବେ।
How much years of practice you have?
7 years.
We are sending you, you go in this weekend. Yeah. Are you available on this weekend?
Yes, ma'am.
You go there and make your inspections and come back. You also cooperate, your officers must be there. You also tell your clients to be there, everybody. They will just show. And also intimate the opposite party number
5.
5 and 6 also. So they have to be there. Fix a date and go there. The instant writ petition in the nature of this topic because the petition is filed by the official. Despite several orders passed in the writ petition filed by the petitioner for removal Copy of this order. Don't record the submissions of anybody. It's not a commission which I have allowed. Simply an inspection, you are the independent person, you will go, they will simply identify, you will go and they see that what is it.
Item number 14.
Item number 11, I was put.
Thank you.
What they call.
You are not there, sir, since they have taken a plea that since last 2 days you were not there.
No, sir, last, only one time I was not there, that what happened. And the,
No, they say that since last 2 days that you were not there.
Lord, I was in, nobody asked for. On the way,
We is in 11.
11.
Item 11, Millard.
Unauthorized.
The prayer is that opposite party number 5 and 6, they are encroaching upon the public road, Millard. Millard, on 24th November, no, 24th December, I have obtained instruction that already that eviction is, they are already evicted.
So what remains, they have already been evicted.
You know, that's just listen to one knowledge. Sometimes they are taking the.
Sorry, I will keep it on record. Here it says. The coaches are who we have made a party. Let's find out.
OP number 5 and 6.
Vishnu Bodo Kera. Bodo Kera is there. Vishnu Bodo. All 3 are party.
Land enforcement case or initial. So.
Since
And even a penalty has been realized from those encroachers.
27 to 23, the last order was directed to evict them.
Just a 5/9/2020. Can you bring this on record so that we will take this matter seriously?
Yes. It is not prior to that. But by 22nd, I will think. 27.
We just served a copy on him. We are keeping this matter in 27 as the first matter. It is submitted by the lab.
14.
Item 14 made listen. I have filed the IML sheet. The PIL matter public interest litigation filed for a direction to stop merger of Kendrapada Railway Mail Service with Kotak Circle. I have filed the IML sheet to amend the cost settlement. Amend the petition, but I have not.
Service has been done. IE.
No, I have received, but they are supposed to serve it on this Central Government Council for the Union of India.
The one the email was. Next week.
Item 15.
Instruction.
Item 15.
Especially against illegal extraction of the minor minerals, which has ultimately affected the sites which is of historical importance. Ratnagiri and Lalitagiri Cave Mill. Besides that historical places mill, there is a connecting road, and because of the illegal extraction of minor minerals, the government has issued the operational procedure at page 24, Annex 4, you will also kindly see. That several instructions issued that the lessee should comply with these procedures. The modern
earlier one PIL was filed before this honorable court alleging excess mining activities beyond the permissible limit. That PIL, your lordship may disposed of disposed of with following directions. Now, in the meantime, on the basis of further allegation, matter is pending before the NGT, and the NGT has directed to conduct an inquiry and submit the report. And the date has been fixed to 19/3/2026. Your lordship, this is the order passed by the NGT, where NGT has also taken note of the order passed of this honorable. And my instruction on WhatsApp that they have taken all corrective measures, but still I'll have to produce it by way of an affidavit before this.
Advisory that this, there should be an installation of the CCTV, there must be a pillar posting.
Yes.
GPS surveillance, then the installation of a signboard. Vehicle must be VLTT, registered to maintain at source point and.
Regarding that, I'll file further affidavit regarding that, because readily it is not available. I'll produce all.
With your own advisory.
Yes.
So you have to.
Whether they have followed it or not, and because there is a specific direction of this honorable court, so also we have produced.
Private police parties.
no private or public party.
Lessee,
No,
the
State pollution.
Sia State Police and the Manduka stone quarry, against whom they have alleged that stone quarry has not been.
Salient for notices.
that is what we are being. Pleading for.
Others, Mr. Last is opinion.
No, but it is, we have no allegation against any individual miner. Only the operational procedure is to be followed so that the sites can be done.
Here for. Here.
Item 16. Item number 16.
The petitioners have, I have received instructions that a joint committee has been formed to conduct the inquiry into the grievances of the petitioner. There in the inquiry is going on, and it's
আমরা যদি প্রাইভেট রুট মানে এগুলো হচ্ছে এক্সিকিউটিভ
Once the report, the inquiry is still in the progressing, my lords, 3 weeks' time, the report will be submitted. The survey report is awaited. The inquiry is still in progress.
May I please, Lordship? Lordship, it is a matter pertaining to construction of a village road in Rajpanika Tahsil, under Rajpanika Tahsil. That is the Uppuli to Bodapunka, it is a 5 kilometer road, the highest bidder will be selected, but he's not constructing because only one person is obstructing the road on the edge of that the land is belong to him. So that's the important.
Which matter you are referring?
Item 7.
It is a within only.
Yes, sir.
Your case is different. That's why I am asking. Your fear is why the opposite party number 5 will not be directed to evict opposite party number 8.
Lordship, he
And
is
is
obstructing
eviction from the public road.
Lordship. He is obstructing that particular road in the name that.
Why the opposite party number 5 be not directed to inquiry into the land which is in possession of the opposite party number 8, and it is found illegally ROR corrected.
Lordship, my prayer is that the opposite party number 5 who is in charge, who is telling that the particular land belongs to me, actually that is not belongs to him. And there is a direction in his.
So it is a dispute on the title. If it is a dispute on the title, why the PIL lies?
Lordship,
How the PIL?
construction of a village road.
How can you say it is a village? If he has a title over the property, then it is not a village.
It is a regular conveyance place since time immemorial, Lordship.
So
And,
what that may be, it does not mean that it changes its character by a passage.
No, I am not asking that the nature and character of the, if he has the title on the
If it
same
is a,
name,
if he has a title, he has a title. Go there and challenge.
Lordship, we the villagers and our.
Maybe villagers, you cannot challenge the title of a person unless you have a rival title.
Lordship, it is a 5 kilometer road. Your
Sorry,
Lordship may consider to that
It's not a
aspect.
construction. He is having a title. What is your instruction?
That's, although we have been arrayed as pro forma opposite parties, my lord, I have obtained instructions. My lord, another person.
Proforma,
My lord, we have been arrayed
what
as
is the state proforma?
the 1 to 6 are pro forma opposite parties, my lords, and
No.
Opposite parties considered the opposite parties.
Directives of private opposite party from the government is representing.
Yes.
yes, my lord, in this case, my lord, previously, the encroachment cases have been initiated and my lord, the formalities have been completed. Now, my lord, the date for eviction has been fixed to 31st of this month, January. Previously, it was scheduled.
Appeal everything over.
They have not preferred appeal, my lords. As it appears, my lord, the encroachers have not preferred any appeal. They have not said anything about any appeal.
First week of.
Item 19.
Let me see the prayer here. Director Miller, the instruction was sought for the, let's see, kindly come to paragraph, page 4. Page 4, towards the top. After annexure 1, there is these 4 lines. In intervention of the zones of land. And what?
Your Lordship, without reservation, the same, the secretary cunningly converted into Kisham Ghoravari, homestead land, which is near to his house.
Your prayer is different. You are
My
saying
prayer
that
is-
why the cooperative, primary cooperative society office at Godam be not constructed at Pundi?
Pundi is a primary middle place for the betterment of the farmers. And now the secretary shifted it to his house, near to his house, which is for which the farmers are facing a lot of problems from bringing seeds and fertilizers.
Where they will construct in Pundi?
Initially, the primary cooperative center at Pundi, functioning at Pundi. But after super cyclone, the secretary of Impact number 7 shifted near to his house, which is far away from the middle place.
How far?
And
How far?
so farmers are
It is within the same village.
no, no. It is a different panchayat and a different village. And Pundi belongs to Kumda Jaipur Mauja. And Kumda belongs to another Mauja. Different Mauja.
How
Different
distance?
distance, more distance, my brother.
Let's see.
So that,
affidavit page. Affidavit page 8. Incident of another village and the occupational licenses.
Oh,
Yes.
easy. Here or there? This court or other court?
I think this.
In reference to Annexure, my lord, Annexure 2, the Assistant Registrar Cooperative Society also issued Annexure 3 for construction of cooperative society as per the demand of the farmers at Pundi.
But we belong to the same place where they are constructing. Kunda.
Punda, my lord, Punda is far away from Pundi.
Who is the deponent? Who is the
A copy of the kind of server.
Who is the petitioner? Your petition
Petitioner
belongs to which village, post office,
my lord,
which post office? sir?
petitioner belongs to
Which post office?
petitioner belongs to Kumada
Which post
Joy,
office?
Nandkishorpur, which
I am asking you which post office?
post office, my lord. Post office, no.
Please come to page 8.
Yes, Kumada.
Page 8.
Page 8, my lord.
Yes. PO means what? PO means what? Post office?
My lord.
Why
Kumada,
are you not reading the post office?
post to Kumada, Jaipur, PS Mahanga, my lord.
So it is a Kunuda.
Kumada, Jaipur, my lord.
And where they are making
They are making, my lord, the opposite party number 7, secretary,
which place?
at Kuhunda. Kuhunda, my lord. the primary cooperative society construction has been made will going to made at Kohunda. Another concept, and another
Page 4, paragraph 7. Proceed.
Nothing. Well, you can't say that where they will, yes, wherever the land is available, they will do it. It must be accessible to all.
my lord, land is available, my lord, at annexure,
Sorry.
at annexure 5. The Sarpanch at annexure 4 also made representation before the registered cooperative society to provide land at annexure 5.
Why
To
provide
construct-
land?
Annexure 5 is the land is under Kunda, Kundi, madam. Kundi village,
Sorry.
which is a middle place. So the prayer of the petitioner is that the cooperative societies may kindly be constructed at Kundi.
The public
Item 20.
In this matter, if we receive instruction, by tomorrow we file counter. I will solve the topic to my system.
Next Tuesday.
Item 21.
Please, I'm appearing on behalf of my senior, Mr. Chandil. My senior is out of station today. The matter may be taken up on me.
2 weeks.
Need care, I shall.
Also, the report is.
Yes, sir. Item number 23.
The 23 mallards are directed for filing of counter mallards. But it's almost very good at a short adjournment will be granted. 1 week time mallard will file it.
Is the first extension?
Yes, mallard, first. That's my call it on third.
Already rejoinder already under the office.
Item 24.
That is 24, we have to file a short affidavit, maybe taken up next week. This is related.
Not a long affidavit.
Relating to whether Gochar land is converted or not. Because the allegation is.
Next week.
Okay.
Item 25. Item number 25. Item number 26.
My lord, item 25. My lord. On behalf of Mr. Das, paper 2 weeks after, my lord.
The first extension. 1 week for the new enter to.
Item 27.
On 27, we have filed the affidavit yesterday. I'm giving a copy to my learned friend mallard, and hard copies are not on record. Yesterday, mallard this file.
By your rejoinder, which we distinct by. We affidavit.
Number 20, to the last quarter, affidavit has been filed in the time just proving a copy. It has been e-filed today, minus.
Go through it. It's a PIR or what?
Yeah.
So rejoinder, if you want to file, you file.
Yes, yes.
How much? 1 week, 2 week, what?
For 1 week. 1 week and done.
1 week. See. Yeah. Professor.
And in court 2 days.
No, served in court today. He's filing in court.
He filed my looks, but copy.
It's called.
Item 29.
This is another university. Transfer of policy, annexure 2 and 3 shows that the government has transferred the person who is belongs
How can you stand in the way of order of transfer?
illegal action of the government, not
What illegal action of the government? A public officer It is a transferable service. It is up to them whether to keep him there or to transfer. How can you come in the way?
This report and Apex Court has Annex 2 and 3 stage, your lordship.
What?
That is the carrier policy, your lordship. Kindly Annex 2 page 15, your lordship.
Yes.
No officer shall be posted in his home district in post like Tahsildar, BDO, Deputy Collector, Additional Sub-Collector, Sub-Collector, RTO.
Yes.
So here the present party is belongs to Ostaranga.
How do you know he belongs to Ostaranga?
Let's see, we are the people from Ostaranga, let's see.
Yes.
And he's influencing and let's see, his relations are belongs to that.
So what? There may be a relations across the country. That means that no person can be posted anywhere.
In his home district, let's say Annex 3 also.
You don't know home district.
Yes, let's see. It is the officers belong to the.
What is this? Has it been posted in the home district or no?
No, not in
No.
the home district. That is my instruction.
Correct.
But whether a EIL is maintainable in a
It's
service
not
matter,
maintainable, I know.
it is not maintainable. There are judgments, and so far as the recent judgment of my lords in writ appeal, the scope of interference so far is
I know, that is what I am asking. And public interest litigation.
yes.
It's not there. We are recording that. That's all.
Let's see. Let's see. I have.
It is the Yes, the director is Mr. Sultan.
This is rectangular. Demarcation of the government land is already conducted and proceeding is already initiated.
Already done, what more? You wanted the removal of the encroachers, they have already demarcated, they have found encroachment, they have initiated a proceeding, they have to activate the process of. There's disposed of.
31.
But it has already been done. Proceeding, what would be, that point has already been. Only people can be expect that it should be brought to its logical way.
Please, my lord. My lord, here, last occasion, my lord also direct. Yes, last occasion, my lord also directed the state government to obtain instruction for removal of the illegal encroachers over the vast government land, which has been obstructed by the illegal
Government land.
Sir.
Or small government land.
the vast government land.
It's not.
That is their land which
What is the measurement?
that is the map I have also annexed. Map, the green. Sir, page 16.
1/6.
1/6, sir.
3 acres.
Yes.
What? I do not find.
Page 16, sir. Page 16.
Yes,
1.
What?
Sir, this is the 8 acres. 8 acres of land.
Sir, you are privileged, I am not. What is
Sorry,
green, what is
sir.
red, what is blue, I do not know.
Sir, this is Sir, this is online. Sir,
Which one is?
Sir, green ink mark. That is the 8 acres land, which is a very precious land, sir.
The vast, 8 acres is small.
No, this is
I just thought that 200, 300, 400 acres of land.
total area of a
You just thought you talk about the vast land.
Sir.
Anyhow.
Sir.
Yes.
Let's have given them instructions. Let me see the third page. The eviction process was initiated. They were given eviction notices. That some challenge before this honorable court, the eviction notices. My lords, their writ petition was disposed of, giving them liberty to file an appeal before the sub-collector. And my lord,
Unconditional order.
they have been directed that no coercive action will be taken.
Who?
My lord,
Honorable single judge, sir.
my lord,
What?
my lord, please see the third page of the instruction. When the encroachers came up, my lord, challenging the eviction notices. The writ petition was disposed of, giving them liberty to file an appeal before the sub-collector. My lord, and my lord,
Simultaneously,
yes,
no
my
court say.
yes, my lord. And my lord, so they've said that for 3 months, no coercive action is to be taken. So we have to.
Go by the government rule.
And my lord, they have thereafter preferred an appeal also. So, my lord,
What? If the court has passed an order, what?
Now, my lord also, the division bench also directed for the illegal encroachers should be evicted. That is there. We have brought it to the notice of the honorable single judge. That is the order passed by the honorable division bench. And that is also the order passed by the honorable division
What the
bench.
single bench has done.
He has also passed the stay order. They prefer an appeal within 1 month or 2 months.
What you were doing.
We have also brought it to the notice of the honorable single judge. Then we brought it also. There is an order passed by the honorable division bench.
What?
That no stay order and also directed for immediate eviction of the encroacher over the government lands. Huh?
If the single bench has passed an order contrary to a division bench,
Sir.
then what the litigant is supposed to do? I am asking. You are the litigant.
Yes.
What you are supposed to?
Sir. By way of writ appeal.
I do not know. That's your wisdom, sir. It's
Sir.
your baby. You have to nurture your own baby.
Sir.
The other will not advise you how to nurture.
Sir.
If there is already an order operating, can't do anything.
That is for individual, single individual only, not for others. Sir.
Yes.
that
Single individual, not for others.
That, my lords, I have not obtained instructions, my lord. Whether they
We did not say that the bar without looking at it, I understand.
No. My lords, whether there was a single petition or there were other petitioners, my lord, I'll have to.
Has it been disclosed in the written
No,
that
no, no.
those matters are written there? Obvious facts are stated.
No, my lords, what my learned senior is saying that previously there was a direction by the division bench. That was not in his case, that is somebody else's case. They have annexed that and annexed
We have
4.
brought it also the notice of consumption.
That is in,
Once an order has been passed by the division bench, the single judge cannot pass an order of granting stay.
that is in somebody else's case, not
But
in.
in individual case. This is a government land, and also the government has, your government has taken a decision.
But
To evict the
if there is
illegal
a court
encroachment.
order, sir, what can?
Huh? I see. Sir, opposite party number 7, namely Siddhartha Das also brought that file this repeat only single and obtain the stay order. Yes, good to talk. This field is
Appeal is filed. Writ appeal, my lords.
have filed a play. It will be filed.
No, my lords, we have not filed any writ appeal, my lords.
Along with logging of photo, Lordship, without any competence, Lordship can only do, after completion of the contract, Lordship, the tender has been cancelled. And Lordship, they have come up with the fresh tender, they have ordered the same, and they have cancelled. After cancellation of the tender, I had participated in tender process. But there was a clause, during technical evaluation, if they will find Lordship that something I have misrepresented, then they can go for banning or blacklisting Lordship. But here, Lordship, they cancelled the tender due to their technical fault. And they came up with a new fresh tender. And the order same. Now the work is going on. After 1 year.
You have been awarded?
No, I am no Lordship. The original contract has been cancelled. Tender is cancelled. I was one of the participants. Lordship, that has been cancelled. Due to their technical fault. And they come up with a new tender. And the order same. In first tender,
Which
because
item is
it's
it? Oh,
on the ground of
Samantara Yachi.
on the ground of lordship, I have given some first document or misrepresented. They have passed this banner.
Where is the order?
Lordship, this order, lordship, kindly see that is Annex 3, page 27.
Where is the order?
Lordship, I have given that order, lordship, because they have not produced. I have given that order, lordship. That is by whom I have given. Lordship, kindly see page 1. Page 1, lordship, plus 3, 2 plus 3. The tender is initially processed for genuineness document submitted by the firms and was cancelled on the latter. Sorry, lordship.
Yes.
Lordship, can you come to a date check, lordship? That is very important. Tender of 24, lordship.
We cancelled.
Lordship.
The question is that what you have done.
Lordship, I have nothing, lordship. Nothing, lordship. Reason being, lordship. If at all, lordship, I am not.
Purchase order.
Lordship.
Fabricated one.
Lordship, maybe.
Completion certificate. Fabricated
Maybe,
one.
lordship. I am not on that, lordship.
I am on that.
Lordship, sorry, lordship. I want.
Why I will not be on that?
Lordship, because lordship.
The parties is one of the constituent in exercising the extraordinary jurisdiction.
Then some competency must. Who is he, lordship, to pass order against me?
Who is he means?
Means, lordship, they are not my employer. The relation is not exist.
No, it's not an employer. You are participating. You are debarred from participating.
No, lordship, kindly come. Page 20, lordship, kindly come to my lecture, lordship.
Yeah.
For a moment, lordship. Please, lordship, the tender, lordship, floated, lordship, on 23/10/24, lordship. Immediately, lordship, kindly come to page 1.
They cancelled it.
No, due to their technical fault, not my fault.
Whatever.
They have cancelled, lordship.
Correct.
And
easy for one reason. But at the technical bit stage, they found everything to be wrong.
Lordship, kindly come to them to the clause itself, lordship. I am saying, lordship, if I have competency, then I don't have any case, lordship. Lordship, kindly come to page 21 for a moment, lordship. Clause 8.
Yes.
21, lordship.
Read.
If we understand that if the contents of the certificate submitted by us are found to be false at any time during procession of evaluation of tenders, lordship, this is very important, lordship. It shall lead to forfeiture of bid security and also lead to any other action provided in the contract, including banning of business for 2 years, lordship. Lordship, kindly come to page, lordship. Lordship, page 26. Miller, they have not forfeited. They have refunded all my amounts. That is on, lordship, 4/2/2025. So, lordship, and thereafter, due to their technical fault, lordship, they come up with tender, fresh tender. So there is no employer-employee relation. There is no. No, I can amend that because my friend would supplement today. I got that.
With the line of cases,
Lordship, I can amend.
line of cases. No. That if a forged or fabricated document or manufactured document is submitted.
That is not the case, Lordship. We have never submitted. That is their case.
Third, they have found.
No, they have found.
The purchase order which you say the completed, you have to show that you have completed certain works. You have to show as a part of the tender.
Definitely, Lordship.
Yes, you have submitted the purchase order.
But Lordship,
They have submitted the completion certificate issued by a authority.
Yes, Lordship.
They found that this not only the purchase order but the certificate by the authority are false.
They can set on their own, Lordship. There is not
Because
This order
Lordship
has come now to
Lordship.
you, it is communicated to you.
yes,
Lordship.
After filing of this.
Grateful, Lordship.
a subsequent event has happened during the pendency of the instrument.
Seven 2025. This is with regard to that, my lord, speed breakers. My lord, the speed breakers were there, the fluorescent light has to be. Para 3, my lord, may see for a moment. May I place it? Para 3.
What?
My lord, this para 3, my lord, where my lord, when the matter is, just I'm placing it, my lord.
Paragraph 3 of what?
Paragraph 3 of the order dated 31/7/2025, 31st July 2025.
Not done.
No, my. I did.
What? 36. Been done. No, I've seen. That was the assurance which was given on that last day. Where is he? Where is the learned advocate general?
But you are a second.
6, 77.
And that was in the month of July. Now more than 12 months have passed. Where is the learned advocate general? Go and inform it to appear before us.
Thirty-eight.
Actually, I am for the petitioner. This is a
This is a VI case filed by TANDON in respect to child victim. And the child victim, age was 16 years old.